Linda, she's the Human Resources Manager, Site Human Resources for Health Central Hospital. Linda has over 10 years of human resources business partner experience, specializing in leadership development, performance management, consultation, and organizational development. Linda is the human resource business partner at Health Central Hospital and is leading the culture, process, and policy integration in the organization. Linda also has strong experience in recruiting, legal compliance, policy creation, and mediation. Linda has her National Senior Professional in Human Resources certification and her Master's in Human Resources from Rollins University. Linda enjoys her role protecting patients, giving opportunities to employees, and helping leaders to be successful and grow their careers, and she's the one who gave me the new rules for employment. No. Would you please welcome Linda Towers? Thank you, Linda.
There's nowhere to go but up from that.
All right.
Well, I will begin this morning.
I'm going to introduce each of
I
them
apologize.
first, but please, thank you. Bernadette, you're a friend here of MOROF for some time. We've come to know you quite well. She's the president and owner of ABC&D Consultants. That acronym defines her mission: accountability, business, coaching, and development. This is the focus of her business consulting for both business and medical professionals. She first began her career as a certified medical assistant. She also has her BBA, that's a Bachelor of Business Administration, and has the pleasure of working for physicians both clinically and administratively. Over the past 8 years, she served in the academic environment as a medical assistant instructor, program director, and held the title of Associate Dean of Academic Affairs. She has trained and developed over 4,000 adult learners and managed over 30 instructors across 7 programs. Her background and experience is extensive in training, development, and human resource strategies. She has an analytical visionary who effectively partners with physicians, CEOs, and managers to assess opportunities, facilitate strategic decisions, and she implements the best practices to encourage employee empowerment. She's developed successful employee rewards programs that are still in effect today. She's founder and creator of the leadership program at a local college that has won the President Obama's honorable mention for the past 4 years. She's known as the virtual HR lady, and as part of the Practices Managers Toolkit, she can help create a smooth-flowing clinic, assist employees and managers with professional leadership development. Please welcome Bernadette. And certainly not last or least or that whole thing that they say.
I got to work on my bio.
All right, Jim Henson. Not at all. I was pretty impressed here. And he's an associate attorney with Mateer and Harbe, where he practices in the area of labor and employment law, professional liability law, corporate and business law, creditors' rights, and is part of the firm's litigation and appellate practice team. Mr. Henson has represented both plaintiffs and defendants in a wide variety of matters. He regularly represents employers in a wide range of issues before state and federal trial courts, as well as administrative agencies such as the Equal Employment Opportunity Commission. He provides advice and counsel to his clients so that they can comply with the myriad of laws which regulate the employment process. Prior to obtaining his law degree, he spent over 10 years in the hospitality industry and is part of the senior level management. And I'll tell you where this presentation is going today. Senior level management for several large Orlando area resorts, including the Hard Rock Hotel Universal Orlando, Nickelodeon Family Suites Resort. So we have an idea that you've been dealing with some pretty big organizations and fun organizations. Imagine that.
Yeah,
He received a BBA degree with a focus in human resource management, and an MBA and his JD degree from Stetson University. Mr. Henson is a member of the Florida Bar, Society for Human Resource Management, and the Greater Orlando Society for Human Resource Management, and the Orange County Bar Association and the American Bar Association. With all that, I can tell you we've got some great speakers. Mr. Henson, thank you for joining us as well.
Thank you.
Please remember during the presentations there may be opportunities to speak and ask questions. We would prefer to have them all recorded and on tape so that we can get back at you later. No. That was a joke. Boy, I better go back to the ones that are written down. With that, I give you our panelists. Please give them one last welcome.
Good morning. Well, I do want to begin with a confession. Many years before I got into the field of human resources and before I was in healthcare, I managed a team of people who worked 24 hours a day, and I was looking to replace my excellent night shift team member. And so I began the interview process, had some excellent candidates, and I made the wrong decision. And so I wanted to share with you the things that I've learned since then that have made a tremendous difference in the way that I recruit personally, and the interview process that I use, and the process that I've seen used very, very successfully where I work currently. So the first thing you need to do is find the right candidate. And I found that asking the right questions, and more importantly, understanding what answers you're looking for, is the true key to finding someone who will be successful in the role. And also doing it in a way that you're aware of any legal issues, any adverse impact. The system that I'm going to show you has been tested at various places and has found that it recruits a diverse group of people, and so that's fortunate, but that's something you'll always want to watch for in your interview process as well. One of the things that I find that people don't do is they have a list of questions that they really like because they find maybe that they get stories that they enjoy hearing from people and they find that they're engaging, but we don't necessarily know how they link to the skills that we're trying to find in our candidates. So I ask my leaders that I support to first list the skills and qualities and abilities of the people that they want for the role, to think of their very best person doing the role now or the best person they imagine someone could be, and write down those skills, and then ask questions that help them flesh out if the candidates they're meeting with have those skills. I also advise my leaders to go ahead and only look at things that are relevant to the information or to the job that they're hiring for as a screening process. Does education meet the minimum requirements? Do some candidates have more relevant education than others? Work history. Will it prepare the candidate to do the job well, or are we asking something to do something that's totally outside of their normal scope? And should we ask questions that help us determine if the person can make that leap? Does the job applicant hop from job to job? Well, I don't think that that's an automatic disqualifier. I have found in my past experience that it's an indication of potentially future job hopping. And then are there long stretches of time that are not accounted for? And then note any questions you want to ask for work history. There are 3 types of questions that are generally asked in interviews. Experience verification, which is a great screening tool when you're trying to figure out who you want to bring in for an interview. Finding questions about the candidate's work or school experience to see if it's relevant. Behavioral questions. The idea behind behavioral questions is a little bit psychological, and they're very popular right now. You ask employees or potential candidates what things they've done in the past in their other jobs, with the idea that past behavior is again going to be an indication of future behavior. And those are wonderful questions, but the problem is we don't know necessarily what to listen for when we ask a behavioral question. What exactly are we seeking to hear? What's going to tell us what we need to know to find out if they're going to work well for us? And then situational questions are the most common. They ask the candidate to discuss hypothetical situations and tell you how they would respond. And those are excellent, and those are the ones that candidates practice the most of all, because it's very easy to imagine what I might do in a perfect world instead of a real-life setting. So the interview usually describes a situation briefly and asks the candidates how they would respond. One of the things that I recommend that people do is to create a scoring system that they stick with, not to find out the actual questions or answers that people will give, but the elements of the right answers, so that you know that your candidate has answered well. And I wanted to put up some examples some things that you might ask, and I kind of predicated on the idea that you might be hiring for a doctor's office, but you can see the relevancy for other fields as well. So what would you do if a patient seems to have difficulty breathing while waiting for the doctor? And then I put some points that you might consider based on a 5-point system. Find someone with basic life support who can observe the patient and assist if needed, or some indication of an acknowledgement that the patient may need immediate medical intervention and that someone with the skills should be called and notified that there's a potential issue. 1 point, to communicate with the physician of any unusual developments. The last thing you want is for the boss not to know what's going on or for someone to not be aware that a patient is struggling. Make sure the patient is seated where you can see and hear them. This is something that a lot of people miss. I think we see those things happen in hospitals even, when people are in triage and waiting for medical attention, and those have been on the news, I think, in other states where we've had people who've died while waiting for medical attention in a hospital. I think it's really crucial to hire someone in certain positions who may have those critical thinking skills that are necessary for patient protection. and to someone who says they would continue to communicate what the patient's status is and make sure that other patients are cared for as well. Another example is to tell me about a time when you had a challenging interaction with a coworker. This is a situation, anytime you've got multiple people working together, that you want to know how that person would handle it. And again, what you're doing with your points, and these are just some samples, is you're saying, this is what I might look for in an answer. And by the way, I recommend that my leaders hire someone who answers the average answers and above, but if you find that person who gets all 5 points, you found an excellent employee. Another question that I like people to ask is the situational question of imagining a scenario where there's lots going on at one time and how people would answer it. It gives you an idea of how people process information and how they prioritize their answers and their thinking skills. People should get extra points when answering questions as precisely as your ideal candidate should, but the more important thing is to see how they gather information and speak out loud about their thought process in handling a critical situation. I wanted to kind of throw us a little bit of a curveball and say, this is, I think, the question that's everybody's favorite. And I've sat in a lot of interviews with my leaders and hear them say, tell me a little bit about yourself. And the answer I've put here is based on actual answers that we've gotten. And I've seen my leaders diligently take their pen and write down every single thing the person is saying. So can anybody kind of see the pitfalls in those answers and maybe some things that aren't necessarily relevant? Yeah, it's pretty obvious. I was born in Panama in 1972. So now I know your national origin and I know your age. I love acting and participating in community theater, which is wonderful. It tells you that maybe they seek a work-life balance. I take care of my elderly father who has cancer. Does anyone know why that's a potential problem? Yeah. They might be a caregiver. And is anyone familiar with GINA, the Genetic Information Non-Disclosure Act or Non-Discrimination Act? Anytime a candidate reveals to you that someone in their family may have a medical issue, they've actually revealed to you something that should not be recorded and decisions should not be made based on that information. And that's one of those easy traps because people tend to share that kind of thing in an interview, and writing it down could be potentially problematic. My next favorite one, I just found out I'm pregnant. That's also a protected class and should not be recorded and should not be relevant to decision making. And I love this. I have done this job exactly. I've got this. One of the things that we teach when we talk about interview processes is interview biases. And by the way, this was my mistake when I was doing my first interview for my candidates. And so I wanted to kind of share with you because this is something that we all tend to do. It happens over and over. We usually let biases unintentionally sway us if we find out that the candidate is like us. And remember that they're reading books on how to interview successfully, and the first thing they're taught to do is to find a way to connect with you. They're to find a way, they'll notice the university picture that you have up or your diploma, they'll notice your pictures and comment on those. Anything you have in their office, they'll try to find something as a way to connect with you, to a way to compliment you. The halo and horn effect. This is wonderful. This is the one I got caught in. You hear one thing that makes you really think that that candidate is just absolutely fantastic, and everything else fades into the distance. Or on the reverse side, you hear one thing that really just stuck with you in a negative way, and it's hard to hear what else the candidate is saying. And that's why I really suggest that leaders go ahead and take notes, very thorough notes while they're interviewing, so that they can go back and score that interview after they're done with a little bit of perspective and distance. Contrast, and this is an easy one to do. If you're interviewing a lot of people and you have that wonderful, fantastic candidate, and then the next one in is pretty mediocre, suddenly they don't look so good, do they? And so that's easy to do, is to contrast them with someone who you've just interviewed. And stereotyping, I think we all know some potential stereotypes that we could fall into based on the way people speak and act and dress and present themselves. And so that's one thing to watch as well. The last one is the one that I find we all do, whether we intend to or not, is to ask questions and consistently. If I were to interview Bernadette and go back to one of my questions and say, Bernadette, this is a customer service question. And I know you know all about customer service, so I really want you to answer this one about customer service. And then I were to interview Chuck and I were to just read the question to James, if I would just read the question to him with no assistance, I would be actually asking a completely different question of each candidate. And that's something that's so easy to do, and I've seen it happen over and over and over again in an effort to help someone who we think is maybe struggling or help someone we kind of like and have that bias towards. We may give them extra points and extra coaching. So one thing about the system that I just showed you, when it's used in its most pristine way, anytime you prompt someone, if they're missing something, you actually deduct a point. And the reason that you would do that is that you don't want to give the same score to someone who answers all 5 points with no assistance that you would to someone who answers all 5 points with 3 prompts, because you're looking at different types of candidates. So then the next thing you want to do is look at your scoring guide, and if you hire for the position often, determine what score is the minimum you need in order to consider if the candidate is qualified. I'll tell you, often it's the average points, the average number of points that people get, because you're rarely going to get a candidate who's going to score your top score, certainly not on every single question. Then, if you don't hire often, look at the score in the notes about skills and qualification to determine the best suited candidate. And then when you go back and rehire for that position, you see how well your candidate answered. You want to test. If someone doesn't survive their first 90 days within your organization, you want to go back and look at their interview and say, what did I miss? Was there something I could have picked up on that would have told me more of the story? Do I need to change my questions, or do I need to change my points? Consider opening up a waiting list and calling people back if there are more positions. If you have a lot of really good candidates, select your top candidates and then keep the rest of those in mind. And then verify, again, that the system works. If you've got escalating turnover, then chances are you need to go back to your interview. Okay. All right. Thank you.
Thank you, Linda. Oh, we just need to switch the mouse here. Well, we could talk about the interview process all day, one of my favorite subjects. I'll tell you, if working at a college dealing with 4,000 adult learners doesn't teach you anything about people and cultural diversity, I don't know what does. I always say that when I was a certified medical assistant working with physicians, I had grouchy bosses and mean bosses. And I said to myself, if I'm ever in a position in upper management, I know what not to do to my employees. A simple thank you is worth a lot. If you can't give them raise, give them praise. And I always say praise can come through training and development. And I'm going to show you what I mean by those things. It shows the employee that they're a very important part of the team. I know that a lot of typical offices like to run on a hierarchy, which is fine and important for structural balance and building that solid foundation. But being a team has nothing to do with who is who. It's about the whole component of getting the job done right, safely for the patients, and profitable for your company. It shows the employees that they're valued. It heightens the purpose of their directive. When you tell them why they're doing what they do, they tend to do it passionately. And if you give them their voice, you know, I always say, if you want to know how to fix something that's broken, ask the people in the trenches. The mother of invention is necessity. And you'd be surprised how much talent you have in your offices if you just ask and listen. It increases employee accountability. When you train them and you develop them and you give them that professional education and tell them how to work with you and not for you, it's a whole different mindset. It increases your employee retention. If you do not think that turnover costs money, I would love to spend an hour and a half with you after this meeting. It really does cost the employers a lot of money, employee turnover. Plus, it stresses out the rest of your staff because they're in constant training mode. And I know what they're thinking because I was there, been there, done that. I don't get paid enough to train these people. Why am I constantly training new employees? it's a real downer for the employee, especially when we're an entry-level position. You know, working at colleges, that's what we taught. We taught new students, new careers, and new opportunities. There's a difference between an 18-year-old college student and a 50-year-old college student. There's a whole different mindset to that work ethic alone. It increases your retention, which increases company loyalty, which increases better productivity, which increases patient safety, which safeguards the physician. I mean, it's just a win-win situation to have these types of things implemented. It increases company morale and loyalty. When I go into a physician's practice, the first thing I ask is, I want to know how many employees do you have? I want you to rate them A, B, C, or D, and I want to know how long they've been working for you. I can give you volumes of information about your company just with those types of answers. The current topic in training today is about the CMS meaningful use. It's really confusing. What's stage 1? What's stage 2? What are all these stages? What's CMS? What do I do now? And it just seems like to the physicians, and I feel passionate about the amount of money the physicians have to spend to keep in practices, and then of course with the low return on top of it, it does get stressful. But if you're very proactive and not reactive, and if you're very proactive to getting your compliances and your training of your staff, it should go a lot smoother. So each stage has a core component and core objectives within each stage. And the medical assistant, there's handouts on your table regarding the CMS ruling. I took this straight offline from CMS, and I gave you each a handout for that to take with you so you could look this information up for yourselves so you can actually read the verbiage and understand it. I just clipped a little bit about what's on your tables right now, and I'm just going to share with you two important paragraphs on page 2 and page 3. I won't take the time to read this to you, but very bold words here. Licensed healthcare professional or certified medical assistant. Years ago, the medical assistants did not have to be certified. Well, now they do. There is national exams that the medical assistant needs to take in order for you, the physicians and medical facilities, to be compliant with CMS. Credentialed medical assistants must get their credentials from the accredited bodies, which we'll go over here in a minute. This ruling, page 3, credentialing for a medical assistant must come from an organization other than the hiring institution. So, for example, if a doctor's office has 5 locations, the HR person can't say, well, you know what, let's just make up a test and we'll certify our own employee that they took this test and everything's good. No, that's not the case. The CMS ruling put this in to say that it has to come from that accrediting association. So, medical assistants, medical billers, and coders, now more than ever with ICD-10 coming in, with CMS coming in, with all these new audits happening, education, education, education. Training and development is going to be key for your people. And then it's twofold. Not only are you meeting compliance, but now you're showing your employee value. You're getting your practices better. Your clinics will run smoother. Everybody will be on the same page. Most importantly, they're going to know what the expectation is of them. CEUs are going to be critical for these employees to keep their certifications active. The CEUs are the driving force to force standards and best practices, update their skill sets for medical necessity knowledge, because medicine keeps moving. Keeps the employees accountable, helps them bring back information to your offices to share with others. Here's some, not all, of the national certifications that they can take. The American Association of Medical Assistants is the AAMA, and that's where they get their CMA. This association is the oldest association in the country. The certifications are national. They are not state certifications. They need national certifications. So If a medical assistant takes their test here, they can go to Nebraska to work, or New York, or Ohio. It doesn't matter. That certification does go with them. So no matter where they test in the country. The next one is the American Medical Technologist, which is the AMT. Don't be confused between a CMA and an RMA. They mean the same thing. They're interchangeable terms. It's still certification. And then, of course, the National Certification for Competency Testing, which is otherwise known as the NCCT. Again, these aren't all of them, but these are right now the ones that Orlando, Central Florida are tending to stick with right here. So I wanted to put those on there for you. How do I get them certified? And as an employer, am I responsible? Organizations that I'm coming in contact with right now are assisting with their employees. They're also saying that, the job descriptions are changing. They're saying that if you're not certified, you need to get another job because we need to be in compliance. So how do you come out of this not looking like a bad employer or getting your brand, getting that reputation that you've just let 8 people go because they didn't have this exam and they've worked for you for 5 years? Well, first of all, you don't want to do that. You want to come out being more mentoring and more coaching to help your employees succeed. You want your employees to succeed. So organizations are maybe sponsoring an online program that they can pay for. This is part of the training and development and component. There's certification boot camps out there. There are books. There are colleges offering some assistance. There are some employers who are saying, well, I'll pay for the boot camp, but you pay for the test. That way the employee has an investment. You're not putting out all the money. If you split things with them or do a payroll deduction, that's fine too. And that really helps. You can provide lunch and learns for your employees as part of training and development. You can have guest speakers come into your offices. That is a very big morale booster. You could send them to workshops. There's plenty of resources around for workshops and that type of development. Vendors love sponsoring workshops. If the physicians reached out to their vendors and suppliers and people that they have business-to-business development with, there's tons of people that would not mind at all bringing lunch and learns to your facilities. Continuing education and training, no matter how small, is appreciated to the employee, and the concept is key. To happy employees are productive employees. I hate to be so cliche-ish about that, but it is true. This week is Medical Assistant Recognition Week. October 23rd, yesterday, was Medical Assistant Day. I don't know how many of you knew that, but these are the people in the trenches working very hard for the physicians in their private practices. A pizza party, a card, a cake doesn't cost that much, and it really goes miles and miles. It just shows that you care. Remember what the old saying is, people don't care how much you know. They want to know how much you care. And that's it for me, and I'll turn it over to James. Thank you.
First, I want to start off by, I looked up my slides over and over and over, and I sat here and I realized immediately that ampersand right in the middle, Fair Labor and Standards Act, that's not there. That doesn't exist. I don't know why it's there. So it doesn't mean anything other than say that if someone else knows it's not supposed to be there, I want you to know I recognize it too. Just too late. I always get asked, can I be sued for this? That is such a bad question. Because the answer is yes. You can be sued for anything. Will you win, or can we get it dismissed quickly is the better question to ask. And can we get maybe any fees you have to expend to defend yourself? That's the better question. That's what I want to attempt to show you a little bit here today. For some, I hope all of you walk out there and say, I knew all that. Because if you do, then you're in great shape, and there's really nothing. But if you take any one nugget about this away from anything I talk about today, except for that ampersand, then it's hopefully will be helpful to you. Pretty much what I want to talk about is the biggest risks employers run today with employees and getting sued. And yes, 9 times out of 10, it always happens after separation. I've never had any employee tell me, you know, I was let go, but it was for a valid reason. They're always upset. They're always mad, even if they've been written up 5 times, 6 times in the last 2 months. That's a real scenario I was faced with. They didn't question the validity of any of those write-ups, but they still thought they were discriminated against. So in any case, one of the major issues is the FLSA, Fair Labor Standards Act. It's, as a lot of our laws go, it is a federal law, and it is one of our oldest. It is 75 years old as of this year. It establishes basically your minimum wage, which right now federal is $7.25. I think everyone probably knows that in Florida we have a separate. A couple of years ago we initiated a separate minimum wage, and ours is $7.79. These are all for standard cash. Standard doesn't include tip out, but it also, the FLSA also establishes overtime rules. Florida has no overtime laws, so if you are sued for not paying overtime, it will be under the FLSA. It will not be under a Florida law. It establishes record keeping, which we'll get to in a second. That's a major issue. Child labor, which I won't speak about today, but if you have that issue, call me. And it covers more than 130 million workers in the U.S., which is just huge. There are exemptions to some of the overtime laws, which again, I'm not going to get into a whole lot today, but just so everyone's aware, to being exempted from overtime as an employee, you have to be minimum of $455 a week, and fall under the professional exemption, administrative exemption, computer professional exemption, executive, or outside sales. If anyone has any questions about those later, I will certainly be happy to talk to you. That's not going to be the focus, but there are exemptions to not having to pay overtime. Again, I think most people here know that. This is why I want to talk to you about FLSA. It's a 75-year-old law. I just tracked the last 13 years here. You can pull this graph up online, FLSA claims by year, and you'll find it. In 2000, there was a total of 1,854 claims. 13 years later, and this is as of March, ended March 31st of this year, there was 7,764. That's about a 420% increase for a law that is very old and very well established. And what that doesn't take into account, those are individual lawsuits. What that doesn't take into account is 9 times out of, well, okay, now I'm throwing out arbitrary statistics, but it feels like to me, 9 times out of 10, if you see one FLSA claim, you're going to get more. Because lots of times it comes down to I wasn't paid for my break time, or lunch deductions are automatically taken out, and I didn't take a break. Well, if you're doing that to one person, chances are it's happening to someone else. And then you get these, FLSA claims are not called class actions. Everyone's familiar with class actions. Class action is where everyone within a group is included in the lawsuit, and then once a settlement's made, you can choose to opt out. A collective action, which is FLSA, everyone has to choose to opt in. And it's a lot easier for the person who gets fired to file the lawsuit and then allow everyone else who's still working there to opt in. They feel less, it's a lot less deadly for them. At least there's a retaliation component to this also, by the way, but it feels a lot less deadly to them to opt in. Well, you know, I'm just getting my fair due. So be aware that while that 7,764 number is big, there's a lot more individual plaintiffs in there. Some of the basics. There are different tests to determine how this is going to apply to your business, but let's just assume, for the most part, the FLSA applies to almost every employer. If it involves interstate commerce, meaning if you purchase any goods that were made anywhere else other than in Florida, you're probably involved. If your business is near an interstate, because you are easily accessible to those traveling, you're going to involve interstate commerce. So for the most part, the FLSA will apply to you. As the employer, you have responsibilities. Time records and pay records must be maintained for 3 years. The reason why they must be maintained for 3 years is because that is the statute of limitations to file an FLSA claim. Technically, it's 2 years to file a lawsuit claiming that I wasn't paid for the time I worked. I wasn't paid overtime when I should have been. And if it is found to be intentionally done, then you can apply for the 3rd year and be paid that extra year. Therefore, the time records must be maintained for that long. What does that mean for an employer? If you have electronic time records, it's not so bad. People are clocking in, clocking out, and they're responsible for themselves. Where it becomes deadly is if you have electronic, and again, I go back to the automatic lunch deduction, that can really hurt you. UPS, now this was a state and FLSA claim, but UPS in California was sued. I want to say it was a $55 million settlement. That's big. Now I know UPS drivers, at least in Florida, are paid $33 an hour, so it's it's a union contract, so you have a different scenario there. But they were automatically deducting an hour for lunch, and a lot of these guys weren't taking lunches. In UPS, they have their handheld. They know how fast you're going. They know if you're backing up, going forward, how long you're stopped to make a delivery. So they had all the information. So I can only assume they knew that if this went, they had no defenses. They were done for, and they made a huge settlement. And unfortunately for UPS, I'm going to make an example of them here. There was also settlements in Oregon, I believe in Washington, I believe one of the Midwest states. There have been suits filed in Florida. It is automatic deduction for lunches, and at Hard Rock we did this all the time. I didn't realize, I don't think anyone realized how deadly they are. From what I understand, they don't do that anymore. But be very careful, because that can really, really come back to bite you when you have people who don't take their lunches, even though they say they do. So getting back to the time records and the maintenance, if you don't have electronic records and your people are signing themselves in and out, or as the employer, you're just they're supposed to work 8 hours a day. That's what I'm paying them. When the employee signs for their check, they better sign for their check and sign off that the hours that they have are accurate. Otherwise, the burden is on you as the employer to show that what you paid them was correct. It sounds kind of strange. Someone leaves, they're bitter, they file a claim. If you don't have time records to support your version of the facts, I'm telling you to settle. I'm telling you to pay the claim, because the last thing you want is for this to go bigger than it already is with one person. Oh, by the way, FLSA does include attorney's fees. So that's why you'll have an attorney take the case for, you didn't pay my client for 3 hours. Well, that attorney is probably charging $225 an hour. So it's not just the wages you owe that employee. It's going to be 2 times the wages you owe the employee. Plus, you're going to have to pay the attorney's fees, the cost, and everything else that goes with it. We were talking about some of the meal breaks. Nurses are a great example, or anyone in an office setting can be a great example too. Again, you schedule. Everyone should have a lunch break, and then someone calls in sick. Someone doesn't show up for work, or you're busier than you expected, and they don't get the break they wanted, or great office managers we are. I want everyone buy you lunch today. Just sit down. We need to work through it. They don't take a break if they're sitting down and working while they're eating. That's not a break. That is work, whether they're eating or not. And if you don't pay them for that time, you're violating the law. Failure to provide meal breaks. I'm getting ahead of myself. That's what I wanted to get to. The FLSA does not require you to provide meal breaks. Florida does not require you to provide meal breaks as long as the employee is 18 or over. If it's under the age of 18, they are required to take a 30-minute break if they work 4 hours or more. Okay? But otherwise, there is no meal break requirement under federal or state law. But if you do give a meal break, Department of Labor standards typically say if it's 20 minutes or under, that should be a paid break. If you're telling someone to clock out for 15 minutes for a meal break, Department of Labor, now there's no law and depends on what you get, but the Department of Labor is suggesting you pay them for the time 20 minutes or under. I'm going to suggest to you, you pay them for that time too. If it's 30 minutes or over, and again, if they're not working, sitting at their computer, doing whatever else, they suggest that can then be unpaid. What happens between 20 and 30 minutes? I don't know. There's no standards. Again, I would suggest if they're not working, then you can establish a policy, make sure the employees sign off on it, and you'll be okay. But if there is no policy in place, maybe you want to pay them for that time. But whatever it is, and the biggest thing I can suggest to you is have policies and make sure the employees are aware of them. Speaking of policies, I failed to mention this. I would advise against implementing any of Hank's suggestions at the beginning of this session. Wow, I'm just focusing on that meal break deduction, aren't I? Okay. Again, getting back to the collective actions, they're just founded on simple allegations that although the deductions occurred, the employee did not take the break. And it's not just meal break. There's also, I can think of some large major employers who require you to show up to work. They don't let you take your uniform home. You have to show up in time. You have to change there, put your stuff in a locker. Whether that time is compensable or not is up for debate. But I would tell you, if you don't allow them to take your uniform home and you require them to get there early to change and you require them to then change back, that time's probably compensable and that needs to be paid. Not all employers are paying for that time. There's also misclassifications issues under the FLSA. Again, this is a huge issue, and I don't want to go too far down here, but let's just say there's no set definition. I can't tell you whether you have an employee and you have an independent contractor. There is a test. It is not a finite test, but generally, an employee is one considered who performs services for the employer, and the employer can control what will be done and how it will be done. So if the employer is training the employee, they provide all the necessary tools to get the job done. If there's financial control, if the employee really just shows up and they're given everything to do the job, they're given the training to do the job, and they have no financial incentive in it, there's a good chance that's an employee. Versus an independent contractor. I think work in our house, we tell them what we want done, how we want it built, and they bring the labor, they bring the tools, they're paid a flat fee per job. So typically what they've looked at is behavior control, financial control, and the type of relationship involved. I think it's funny, lots of times I hear people say, well, I don't take out any taxes because they're an independent contractor. Really? What in your mind makes them an independent contractor? Because you put a job out, you posted the position, you hired them, you trained them for 2 weeks, they're in a uniform. It's befuddling. So that's the FLSA. I harped on that for about 2/3 of my time because it really is a bigger issue than a lot of people realize. One of the things everyone thinks about when they hear employment law is harassment and discrimination. First, let me start off by saying, if you have managers or supervisors working for you, make sure they know your policies. And make sure they know that if a witness or are told of anything happening in the workplace, they know what to do, and they notify HR if you have an HR department. You should have a thorough investigation policy and procedures in place. Because if you don't, again, you are setting yourself up. Every employee should receive a copy of your policies. They should sign off and acknowledge that they have received it and understand it. And there should be a copy of the policies available for employees to view anytime they want, and they should know where those are at. That is the best advice I can give you when it comes to these type of lawsuits. Because these type of lawsuits are filed more than any other because no one, again, has ever been terminated or has ever been written up or ever received anything and not felt like, wow, they're just singling me out. So protect yourself here. Jumping through this really quick here. Progressive discipline. This is always my favorite. I'm a big believer in having a policy as long as you enforce it. Make sure, again, your managers are trained on the policy. And keep it simple. I won't say the last S. You can't contemplate every possible scenario, so don't try to. Different attorneys may give you different advice on this one, but I always suggest not including the obligatory language such as always, only, must. There's discretion, and if you don't allow for discretion, then again, you're setting yourself up for that ill will lawsuit where you have to defend something that you may ultimately win, but if you'd have just had a little common sense in the first place, and we hear these all the time. Walmart employee, this was last week, Walmart employee fired for coming out and protecting a lady who's being mugged in the parking lot. He comes out and protects her, and because they found that he hit a customer. Well, he didn't hit a customer, he hit a thief, who was attacking a woman. But they had a black and white policy in place, and now they brought that and trying to bring that employee back, but the bad press they took on it, it's just not worth it. So now that wasn't in Florida, but still. Use the policy as it is written. Now the reason why I say that is because this is going to be the one scenario I bring up. Great company I represent. Wonderful people there. I went over their policies when I was first taken under, when I first took them on as a client, everything was right. And then they come up to me and they have a senior VP that after 20 years they're going to let her go. Visual impairment. And lo and behold, I find out that she's been a horrible employee for the last 8 years. They've never once documented her though. They tried to get her counseling. I have it shown 5 years ago. They chose not to give her any more reviews because they were just so bad for a while. And now they want to let her go. And I was like, oh. So they had this great policy and they didn't use it. You got to use it as it's written, because if you don't, you're just setting yourself up for the he said, she said lawsuit. And ultimately, if this goes to litigation, I can tell you the only people that are going to be happy are the attorneys. In this one, I highly suggested that they settle the matter, and that's what we did. They didn't have to give this particular employee anything, and this particular employee ended up getting a very good deal when they should not have gotten one, only because the employer failed to do their job. Whether they were scared, whether they were just easier, but in any case, folks, that's all I have.
Thank you.
Well, is everybody ready to go back and fire everybody that works for them? I mean, you don't want these kinds of problems in your office, do you? All right, we're ready for our Q&A this morning. So again, just give me an opportunity to get with you so you have the microphone. I'm going to kick things off because I've just got to know. I'm going to start with Bernadette. You talked about topics of interest for staff. And I'm thinking, geez, we're going to bring in a financial wizard and he's going to sit down and tell them all about mutual funds and stock things and this and that. And then he's going to try and sell them. This isn't the kind of presentation or speaker you're talking about, right? You're talking about speakers that will actually help them with something specific in their lives. Would you give us one or two examples?
Well, it's, you got to remember your audience. Always fit your guest speakers to your audience, okay? So if you're trying to do a lunch and learn for an entry-level employee, you want to not talk about mutual funds because they probably can't afford it. And I'm being presumptuous. But what I'm trying to say is if the MA needs help with, maybe you know what it could be, that they need budget. They need some help with budget. Maybe they need some help in their personal life. Maybe they need just a good motivational lunch and learn. It doesn't always have to be medical. It could be something fun. It could be something creative. Everybody loves to laugh. And I think if you have a stressful office and you bring in something creative and fun, that would go miles too. But yeah, you're right. Keep the topic specific to your audience and always make sure that the audience has something of value to leave with.
And make sure they're not dry, that they're humorous people, because there's nothing worse than boring your employees to death that way, right?
Right.
All right. It's good to laugh. All right, I'm going to run over here. I'm going to get a couple quick questions in from the back table. Mark.
In today's challenging economic environment, employers and employees are relying more and more on the online job application process. None of you addressed any pitfalls or considerations that might take place during online communications with potential employees. Are there any, or?
Linda, would you get us started on that one?
Absolutely. I think there are, and I think that you probably want to build in some steps into your interview process if you are getting only online applications, which if you're a federal contractor enables you to take advantage of certain regulations having an online or electronic application process. And they have a very nicely written process that you can take advantage of to really limit your applicant pool. That's a topic for another day. But I think it always helps to go ahead and do a phone screen. And if you've got someone who's far away, consider some sort of an online Skype or something like that to get a better idea of your candidate before you invest in bringing them in and using your time. If you do a panel interview, the panel's time, and also the candidate's time. But I think that really looking at the data they present and then asking those pertinent questions will really help you take advantage of getting a large variety of candidates that the online system allows.
Thank you. Bernadette or James, did you have anything you wanted to add to that comments about
Well,
the online?
Yeah, you know, a lot more medical facilities and doctors' offices are putting a lot online, and to me, that's a really huge broad spectrum. I'm talking with practice managers all the time about how they get 400 resumes for one position. How do you sift through that? They don't have the manpower. Usually practice managers are working managers, and they don't have the time to sift through that. So I always say, don't ever turn away somebody that drops a resume off at your door. There's a lot to be said for that person. You know, the old way is always the good way sometimes, and it shows initiative, and it shows, you know, presentation, and so sometimes those candidates shouldn't be turned away.
Shows they want the job.
That's right.
They're knocking at your door.
I do have a question for Bernadette. You've used, in regards to medical assistants, you've used the term credentialing, rather credentialed, certified, and registered. What's the difference when it comes to those three descriptors, or are they all the same, interchangeable?
They are all interchangeable, yes. Registered medical assistant is, what happened was that the AAMA copyrighted the CMA. They copyrighted that acronym for Certified Medical Assistant. So therefore the AMT had to come up with their own, and they coined RMA, Registered Medical Assistant. Then the NCCT coined theirs, NCMA. You know, so they're all interchangeable. As long as the certification that the MA takes is a nationally accredited organization, it's all the same.
Very good. We're over here now. I've got a question.
James, I want to thank you very much for clearing up. I'm an administrator, and you cleared a lot of things up concerning overtime.
Good.
And breaks and lunch breaks and things like that. I require our staff to take a lunch break, but normally they sit at the desk and eat, and I pay them for it, but I always say that it's best to take a break to get your mind alert again. But $450, a salaried employee that works overtime or works more than 40 hours, I have people in the field that are salaried that I require them to turn in a time card simply for tracking, job tracking for my job costs. And I've had a couple times mentioned, well, you're making me turn in a time card, I'm hourly. No, you're a salaried employee, and then a couple of times it's come back, well, you have to pay me overtime, and no, I don't. So can you make a comment on that? Because I've got people that are making, you know, $600-800 a week salary.
Well, that's only one part of it. That's the first part of the test. In SHRM, Society for Human Resource Management, actually has a flow chart. And the first flow chart as it goes through is, do they make $455 a week? Yes. You can go on to the next question. No, not exempt. The next question will be, will they fall into one of those other exemptions that I quickly went through, and silly, but I remember the acronym PACEO. Professional, administrative, computer professional, executive, or outside sales. If they fall into one of the categories of one of those 5 exemptions, then, again, you have to look at and analyze that alone. I've been told that secretaries fall into the administrative role. Well, no, they don't. Not necessarily. Maybe they do, but then again, maybe they don't. It really is dependent. Now, if the people you're telling me and they're turning out, they're working out in the field, if they're doing outside sales, that's one of the few where you've got a pretty good chance. And when I say outside sales, I don't mean necessarily inside on your lot and working on, not in a Best Buy. That's what I'm trying to say. So. I'd have to look technically. To be honest with you, I would have to look at the job descriptions themselves, not just descriptions, but what they're actually providing and doing. But
Yep.
of
And Rodney,
I also do defamation law, so I'm not going to talk about
Rodney,
that.
Rodney, you make sure you talk with James because we don't want to see you with a photo on the post office walls. Next question.
Hi, thank you guys. You did a great job. I have a question about resumes. So when you receive those 400 resumes and you're not obviously going to interview all of those people, do you still have to keep them for a certain period of time? I mean,
What I like to tell people is if you're considering them an applicant, and again, if you're a federal contractor, there are very specific rules about how that works. If you're not a federal contractor or a government contractor, then you have a little bit more of a relaxed standard. But what I tell people is if you're going to interview them, then you need to keep the interview notes and the information. If you're not considering them an applicant for your position, if you've rejected them for some reason, then I don't really have them. People keep that information around.
Great, thank you.
Thank you very much. I have two quick questions, one for James and one for Bernadette. The first question for James is externs or interns, do they fall into that same application of the law?
Yeah, internships are changing as we speak. When it comes to now, when you're saying internships, are they getting school credit? That's the first question I want to have for you, because if they're getting school credit, it falls under a different scenario.
Yes.
Versus, to my knowledge, you don't have to pay an intern as long as you're getting school credit for it. And I say to my knowledge, that's bad for an attorney to say, especially in front of a panel. But you fall under a completely different scenario there. That being said, I can tell you I read an article just yesterday that a very large publisher who was heavily relied upon what they've considered to be internships, there's the whole program's stopping. It's a multi-national firm. They're doing away with it as it stands, only because they weren't paying. They were working them, quite frankly, to the bone, and they weren't getting the credit, or the credit they get was severely underwhelming for what the job they were doing. So,
My question to Bernadette is, do you think that stage 2 of meaningful use will be delayed? There's a lot of buzz going on saying they might delay it for October 2015.
Well, because of the government, I wouldn't like to stipulate a deadlock rule or date, present situation and point. But what I can say is, even though there's deadlines, the physicians are falling seriously behind in all compliances from my seat. So unfortunately, no one likes change, and it depends. We as people don't really like to do anything until our backs are against the wall. And then it's done very rapidly. And then there's T's that aren't crossed and I's that aren't dotted. I think that if you take the time and be proactive and not reactive, I think you'll win the game. But I'd like to play off of the internship question from an academic point of view. A lot of physicians use externship students. Make sure that the affiliation agreements that the colleges give you cover the liability insurance. Most colleges cover liability on the students, and it is for school credit. However, I have seen personally where the physicians like the extra help. It is free help, and they say to the students sometimes, can you stay another 2 weeks? That is a huge no-no, because the liability now is null and void. They are not a student anymore. They are considered a grad, and now you're working somebody without paying them. So please try not to extend those externship hours. Document everything. Keep everything on every student you ever have, because if you don't hire them, again, they can become bitter. And never ever promise that if you work really hard for me, I'll give you a job. Okay, because that may not be the case, because things change. So just be careful.
And I'd like to follow up on that, James. Those interns are just as susceptible to harassment in the workplace. So they need to be brought in a quite different way, don't they?
yeah, you know what? Honestly, sometimes they're more susceptible to harassment. It's in every industry is different, and I may not necessarily be speaking to this particular industry here when I say that, but I mean, you're talking about college kids who come out and maybe they say something they shouldn't or do something they shouldn't, and they get a management or supervisor. My very early on management, going back to the hiring, I remember one time I had an intern coming in, and I brought in my supervisor. I want to be a good manager. I want to get my supervisors involved, and I let my supervisor sit down and go through some of the training. Supervisor was not qualified to do that. I had sat down for all of 2 minutes, walked in late, and he's asking her questions about her physique, about where she's from, to the point where my HR thought I was crazy. I wrote myself up. I swear I did. I wrote myself up, and I gave him a written warning because while he didn't know, he should have known. He should have known part of that. And I certainly should have known not to put someone out there who wasn't ready. And that was an internship, so yeah, it was just bad. So I'll use my own example. I'll throw myself under the bus.
Thanks for sharing. All right, we have we're getting down to our last couple questions here.
James, you mentioned the retention for time records and that type of thing is 3 years. Is there something set for separated employees, retention of their personnel files?
If you have anything on this, let me know. The law is going to allow them to file. As an attorney, I always want someone to keep something for as long as they can be sued for. So my suggestion to you would be a minimum of 4 years. If you have someone who's been terminated, now someone left their own employment and for a better position, but yeah, the best policy is to keep it. I mean, if every employee leaves that you're keeping it, it could get cumbersome, at which point you may want to reconsider. But certainly, every employee you terminate, yeah, 4 years minimum.
And Linda, anything to add to that, whether it's how long you keep it for or why you keep it for that long?
Well, and sadly, if you have exposure, if they've ever been injured on the job and have some sort of exposure, chemical exposure, I think it's 40 years after your building closes that you have to keep that, so, or your office ends. That's worst case scenario. Most times, what I find based on the SHRM rules is that by and large, up to 7 years after they're gone, that there are some things that really hit that 7-year mark, and so we just kind of preserve employee records for 7 years.
Well, I'm sure there's other questions from our guests, but they're going to have to catch up with you after our session ends. So let's give it up for Linda, Bernadette, and James.
Thank you.
Thank you very much for being with us this morning here at MOROF.